Okay, so you've just been arrested for DUI. What do you need to know? The first thing you probably are concerned about is your driver's license. The citation that you were given for DUI is a temporary driver's license that's good for 10 days. This is commonly referred to as the 10-day rule. What is the 10-day rule? Within the first 10 days of getting a DUI, you have to make a decision about whether or not you want to have a formal review hearing at the Department of Highway Safety and Motor Vehicles, or if you want to waive the right to have that hearing in order to proceed directly to have a hardship license. It's very difficult to win these hearings at the DMV. There's a low threshold of evidence that is required. Either you were lawfully arrested and you refused, or you were lawfully arrested and you took a breath test over the legal limit. If you refused, your license is going to be suspended for a year, 12 months, with no driving for 90 days. Or if you blew over the legal limit, your license is going to be suspended for 6 months and you can't drive for the first 30 days. So first offenders usually don't want to take a chance of losing their driving privileges altogether and elect to waive the hearing, and there's a procedure to do that, and we do that as part of the services that we provide to our clients when they get arrested for DUI, so that they can have some peace of mind that they're going to be stewarded and shepherded through the system and be able to make the consequences at least manageable, so that they can fight their case in court. Because what happens at the Department of Highway and Safety of Motor Vehicles, Department of Highway Safety and Motor Vehicles, has no impact on what happens in court. So there's two separate actions. There's an administrative action for your driver's license for either having a breath test over the legal limit or refusing, and then there is a criminal consequence of driving under the influence, in which they have to establish probable cause to arrest you. They have to establish that they can introduce the evidence of the refusal or the breath test was reliable, and all those things are subject to rebuttable presumptions about impairment and video and so on and so forth, and people have the right to trial. And we preserve their right to trial, and we make a decision whether or not a trial is in their best interest after we do all of the work that's necessary, leaving no stone unturned and digging into every aspect of the case that the state has against them. If you have a job and you need to drive, then it probably makes more sense not to have a hearing, but to waive the right to have the hearing in order to be able to proceed immediately to having a hardship license, which does not include the hard suspension time that would be imposed if your the suspension is upheld if you challenge it at a hearing. So for example, you work, your kids depend on you, you have to get to work, the kids have to get to school. The hardship license allows people to drive to and from work, do any necessary on-the-job driving or any driving that is necessary for livelihood, and which is kind of a broad description, it basically excludes any recreational driving. You're not supposed to be driving to the beach, from the beach, to dinner, to the movies, and so on and so forth. And as long as you can establish that your driving fits within a business purpose, then you are allowed to drive with the business purposes hardship license. Okay. Well, what would I say to somebody if I found out that they had been arrested for DUI? I would tell them not all lawyers are created equal. Many lawyers claim that they know what they're doing in a DUI case. DUI defense is one of the most sophisticated areas of criminal defense that there is. So I would caution them to be careful that just because someone's fee is affordable, that doesn't necessarily mean they have the requisite skills. I refer to some of those lawyers who take cases that, when they don't know what they're doing, is a dump truck lawyer. They just say that they're doing DUI defense, their fees are reasonable, but they really don't know. And you can see here that I'm a founding member of the National College for DUI Defense. I was one of the first 100 attorneys in the country that started the National College for DUI Defense. I was certified by the Florida Department of Law Enforcement to operate the intoxilizer. I've been through the field sobriety exercises course, and I have a lot of information and education and background in doing DUI defense. So I would caution people to not just hire somebody because they say they're a lawyer that does DUI defense. Really make sure and do your homework to confirm that that lawyer really knows what they're doing.